as we say in big civil firms, let's go back on the record. So you have now you've got the hearing set down for the motion for new trial. How you handle the hearing, in my opinion, is sort of up to what kind of lawyer you are, but also what kind of issue are you raising. If you're going to argue that the jury charge was an erroneous statement of the law, then you probably can just have a hearing where you're making an argument to the court, okay? But if your argument is that trial counsel was ineffective because he didn't do A, B, and C, I think the case law says, well, no, at the motion for new trial, you've got to have counsel take the stand so that there's a record of what he did and why he did it. Because usually actions of counsel are, for the most part, presumed to be okay, presumed to be strategic. I had a case recently, in that Canty case, one of the sub-issues was one of my best friends tried the case, and during sentencing, the state wanted to seek recidivist punishment because he was a repeat offender. And the district attorney stood up and said, Judge, the maximum sentence for this is 20 years, and since he's a recidivist, you have to give him 20 years, and he has to serve all 20 years. It's not the law. He has to get 20, but the court still has the power to split it up. He could give him 20 years probation if he wanted to. Well, my good friend said, yeah, Judge, I think the recidivist statutes are really confusing, but I think he's right. Well, I had an issue of ineffective. Now, because the record was real clear at trial that that was a mistaken understanding, I didn't have to have that other evidence during the motion for new trial phase. But let's say your defendant says, I gave my lawyer the name of 3 alibi witnesses. They were out in the hallway during trial and he didn't call them. Well, you know, Ricky, you got some explaining to do. And that's how you've got to have a hearing to give the counsel the opportunity. He may say, oh, I just forgot. Well, you've laid the foundation for an ineffective claim, okay? The idea is how you handle the motion for new trial hearing is a decision that you've got to make weeks in advance if you have that much time. And it does require some consideration and careful thought. Because if you just go in there and say, well, he was ineffective because of A, B, and C, if you haven't laid the proper factual basis for that, you might not get very far with appeal. Get a ruling on the motion for new trial. I have some judges who will rule pretty quickly. I've got judges who will sit on it. In the usual situation, Judge Gates-Pete will go, I'll deny your motion. And lately he got mad at me because I come to the motion for new trial hearing with a blank order saying motion denied, because I expected to deny it. And he always gives me the, you mean you didn't think? I'm like, you kidding me? And he's a really, really smart man. He is a really good judge, but he's not going to grant the motion. And consider this for a minute. What I try to do is I try to bring a written order with me. And I do that because I want to control the timeline. In a recent one, in fact, this is at the Court of Appeals now and could go to the Supreme Court. We went to the motion for new trial hearing. He announced from the bench it was denied, and we presented him an order expecting him to deny it. Now, why is that important? Well, here's my thinking. Once you file that thing, then the 30 days starts running to get a notice of appeal filed. That's one of those, once that's filed, things start moving a lot faster. The other thing is, I want to make sure I know when the 30 days starts. The last thing I want to know is, oh, the judge denied your motion, and the clerk may have filed the order or not. Or in Bullitt County, the order is in this big pile of stuff to be filed at some point. And you know, what matters is when the order's signed, it's when it's stamped in and filed. So what I try to do is bring an order, have him sign it, and then I'll go down there and stamp, file, and file it. So I know when the 30 days runs and when it ends. Yes, ma'am?
If your motion for new trial and hearing is based on ineffective assistance of counsel and you've brought in testimony and there have been disputed issues and so forth, would the judge have to issue an order or a decision that goes through that evidence and makes his fact findings?
No. In fact, they probably should, but what we get is having read and considered the motion for new trial, the motion is denied, period. Those are most of the orders that I get on motions for new trial. And that's a very good example of why I want to get an order myself, because if that happens, when you go up on appeal, you need the transcript, not just of the trial, but of that extra hearing, okay? If you get an order, or you say, Judge, I'll present the order when I get the transcript, you're able to manipulate the timeline so you've got what you need. Does that make sense?
I understand about the timeline, but as you go on to subsequent habeas and so forth, what's the state of the fact issues on the ineffective assistance of counsel?
Most of my judges don't address that specifically. So what happens from my standpoint is, I address it specifically when I file my appellate brief by saying, the defendant's conviction should be reversed because he was denied effective assistance in sentencing, and here's why. So it's like, in fact, I like the general orders because then when I start going up on appeal, I frame the issues the way I want to. Cindy, did you have a question?
Well, it was kind of more of a suggestion. You may want to, before you do that, find out what type of judge you're in front of. Because I've had situations where when I prepared the written order, one particular judge seemed really taken aback by it. He's like, I want the state to prepare it because they're the winning side. They should be the one. And then I had another situation where a judge, I don't know if y'all know Judge Kathy English from Survivor. I mean, he never grants a motion for new trial, and I had one prepared, and he was like, you had one granting it too, right? And I'm like, yeah, right. But yeah, I mean, it really does, depend on the judge too. I think it is a good idea, because I've had situations where they finally issued the order, and then we never get a copy of it. And then the 30 days run out.
Right.
So at least if I have the written copy, I know that, okay, this is the day that I need to file my next appeal.
That's a good point. That goes back to what Perry Brandon taught me 20 years ago. Number one rule of being a lawyer is know your judge. And that's a good point. You need to get a ruling, and it needs to be in writing. Then, once it's in writing, it's denied, and it's filed, that 30 days begins to tick. And that's when you're preparing your notice of appeal, as Chris talked about. And he made a good point. You need to determine at that point, what court am I appealing to? Because it has to be stated in the notice of appeal. And this happened to me in the sex offender appeal. Gerard and I were at the Supreme Court the same day when I argued the cruel and unusual punishment aspect of the sex offender statute. And I filed my notice of appeal. And weeks went by, and I heard nothing from the Supreme Court. And I went over to the same clerk I've been talking about. Oh, I said that weeks ago. And I was pulling my hair out. I didn't have much to pull out, but I went over there, and finally, one of my friends who works in the clerk's office, and may well be the only competent person in there, went and pulled the record. She did send it to the Supreme Court at the wrong address, prompting me to say, in Bullitt County, it's easier to win a case to the Supreme Court than get a case to the Supreme Court. But, that's a little thing. You kind of got, those things happen. This is when you have the clerk's offices were moving to other places. She hadn't kept up with it. So now in my notices of appeal, I put in there, this case goes to the Court of Appeals, and I put the address in bold. I mean, that's kind of tacky, but you need to determine which court it goes to. It could go to the Supreme Court, it could go to the Court of Appeals. It depends really on your issues. Then you file your notice of appeal within 30 days of the denial of the motion for new trial. And it's important, this is something, a lesson I kind of had to learn, is the order on the motion for new trial may be signed by the judge, and the clerk may say thank you, but they could have a big stack of stuff to be filed. And until that thing is stamp filed, it's not really filed, okay? So just be careful of that. It's 30 days. The notice of appeal has to be filed within 30 days of the day the judgment is entered, which is stamp filed. Gerard.
Hey, one suggestion or something I do, and this works really well in a county that has electronic, docketing that you can look up on the internet like the CAB. I don't know how many other counties have that. Is after I have a motion for new trial hearing, I then put on my calendar 30 days, file the notice of appeal. And then I just check, and if there's no order, then I move it down 30 more days. And then I'm just, because there are a lot of judges, or there's some judges in particular I can think of in the cab that I'll never get the order.
Right.
It'll just get filed and that'll be the end of it. So if I'm not affirmatively checking every 30 days, that way I make sure I don't miss the deadline.
And the flip side of that is, you might have judges who heard your argument on the motion for new trial and haven't issued an order, and maybe they forgot about it. I have a case right now where we had a motion for new trial hearing in Scranton County with Judge P, and he said, well, I want to think about it on this one issue. But he's been thinking for a long time, and I think he just forgot about it. So I sent him an email that said, this is a friendly reminder, I still need an order on that. Okay, thank you. I can't figure out what he's doing, but sometimes you kind of have to prompt them.
So if you have had an evidentiary hearing on ineffective assistance, and don't you want to wait until you get the transcript of that hearing and review that and determine how you're going to present that argument in the appellate court, and then after you've done that, present the judge with an order?
Yeah.
And can you count on the judge not going ahead and entering an order before you've done that? I guess you ask the judge that you'd like to review the transcript, and then subsequent to that, present him with an order.
I think that's a good way to do it. The judges I'm in front of, and all judges are different, okay? Some judges are self-starters who will issue their own orders. And mine are kind of like, I'll deny your motion, you want to submit me an order? You know, and so you kind of have to, we're given the opportunity to manipulate that timeline. That's a really good point. You do want that time. You want to be able to get the transcript of that ineffective hearing, but also a chance to digest it. Because it may end up being, well, it didn't work out the way I wanted it to, so, or it might be, wow, this raises a whole new issue I've got to research. What happens when the notice of appeal is filed is the clerk of the trial court has to pull the record together. And the record, as Chris indicated, is the transcript, but also all the stuff in the file, and sends it up to the proper appellate court. Once, you know, and then she produces an index. Go look at the courthouse file. Go look at what she sent, because what she's supposed to have copies of what she sent. One of the cases at the Court of Appeals now is, went up there, and this clerk's a good friend of mine, and she sent some stuff up there, but she didn't send the whole record. There were a couple transcripts that weren't there. There were some charges. I was making a jury charge argument. She hadn't sent the charges up. So don't assume all the clerks know what they're doing. So go over there and pull the index of the record and see what all she sent up there to make sure, if you've got an argument, for example, that a charge was erroneous, you want to make sure if you submitted, or the trial counsel submitted a proper written instructions at trial, you want to make sure that goes up there. So the Court of Appeals knows you've preserved the issue for appellate review. Jim?
Right, yeah, I was just gonna suggest something. I know that this happens in some jurisdictions, that, you know, where people have good relationships with the clerk's office, and particularly the people who transmit the records on appeal. And what'll happen is that they'll just arrange for that deputy clerk to call them, you know, give them a call when the record is ready. And both sides actually can come over and just give it a look over and make sure it is complete before it goes over. So if you've got, you know, if you're dealing in a place where you know, you can do that.
That's helpful, because you might say, well, you know, he denied my motion to suppress, and I want to make sure the actual motion goes up. You want that included?
Or the request to charge, which, as you say, are frequently omitted. A lot of times they're just simply given to the judge, and they just never make their way to the clerk's file. I was going to say too, that's a great juncture to get an index to the record as well, because you're going to need that eventually when you write your brief. And the clerk will actually prepare that and send it up with the record. So if you're going over there to check, you know, grab that.
Well, once that stuff goes from the clerk to the appellate court will send you a notice called the notice of docketing that Chris described. The one thing to remember is, at this point, you get the notice of docketing. It says you have 20 days, and they must send it with a 2-cent stamp, because every time I get it, I've already lost almost a week.